and welcome to a Newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hi, Richard.
Hello, Lizzie. Miserable day.
It is. It's the nights are drawing in now. We're doing this under the cover of darkness, which feels a bit depressing. But anyway, we'll cheer ourselves up with a new case, new Court of Appeal judgment from the 11th of November called Clapham and Narga, and it surrounds adverse possession. So do you want to start by telling us the background facts to the case itself?
Yes, it seems that it's Mr. and Mrs. Clapham and Mr. and Mrs. Wright, who are neighbours. They seem to have owned these two properties in Thrussington in Leicestershire for some time. And to the north of their gardens north of their land was the house was their garden. And at the end of the garden, there was a brook, a little stream, very nice. And and to the north of the brook, there's a fence. What then happened is that Ms. Narga's predecessor had been registered as first registered proprietor in 2003, in March of 2003. But she acquired the land sometime in early 2020, during the first lockdown, seemed like a lifetime ago. And she acquired land at the back of a place called Brook Barn. And it said on the land registry plans, on the title plan, it seemed to show that she actually owned the brook. And she then seems to have got into needless sort of disputes with Mr. and Mrs. Clapham and Mr. and Mrs. Wright. She demanded a license fee if they use the land on their side, if you like, of the brook. And she tore down the fence, so what was left of the fence, it seems to have been in a state of decay, and put her own fence purportedly through their garden. They had an interim injunction was awarded against her. And the litigation started, and everything's in various areas, including adverse possession. But shall I tell you some of the background?
Yes, if you can give us a bit of the background law around adverse possession.
It's quite complicated, adverse possession, and it depends to some extent. It all changed in 2003 on October the 13th. The 50th birthday of the then Chief Land Registrar, I remember well. I remember the party. When the Land Registration Act of 2002 came into force on that day. Because it's completely different in unregistered and registered land for new claims arising since 2003. The adverse possession in unregistered land you can claim after 12 years, Crowns 30 years, foreshore 60, but you can claim after 12 years. You have to have a sort of intention to possess and a actual body of possession, occupation of the land. And in unregistered land, you can, if you claim adverse possession, you tend to get possessory title, which you can upgrade at a later stage to an absolute title. Historically, then, the Section 75 of the Land Registration Act of 1925, which wasn't repeated in the 2002 Act, said that if you could show the 12 years adverse possession, then it would basically be held on trust, on bare trust, for the person carrying out the adverse possession. So that's what would have happened back in 2003, the first registration of Brook Barn. Yeah, but so Section 75 wasn't repeated in the 2002 Land Registration Act. What the first instance judges said was that basically you would have been able to claim adverse possession. As it occurred before 2003, what happened is that you would have an overriding interest. Remember, it's something called Section 70, subsection 1, paragraph F of the 1925 Land Registration Act. There were some interim provisions, but to claim adverse possession for 3 years, Section 70 still allowed you to claim against third-party purchasers and the likes. But even though you haven't been registered as the new proprietor, that came to an end on the 3rd anniversary, October the 13th, 2006. And now you can only claim that your adverse possession binds a third-party purchaser like Ms. Narga if you have an overriding interest under Schedule 3, Paragraph 2 of the 2002 Act. This takes me back to my lecturing landlord days, Lizzie. And that depends on you having rights in the property, i.e. through adverse possession, and being an actual occupation of the premises. But it goes on to say where a reasonably careful inspection of the land wouldn't have found out about the rights. In the first instance, judges decided you might have had adverse possession, but it didn't bind third parties, Ms. Narga, because the fence was in a state of decay and she couldn't reasonably have found out about it. But then he went to the Court of Appeal. It's been going on for 4 years, apparently. More of that shortly. Shall I tell you the Court of Appeal decision?
Yes, please.
It's... I'm sort of at times I was a bit confused about what they were saying, quite honestly. And but the Court of Appeal said that you've got 12 years adverse possession prior to the first registration. The Wrights and the Claphams clearly had adverse possession, because the fence was there to the north of the brook. And they then went on to say that Ms. Narga, who'd been relying on the filed plans and the like, shouldn't have done so, because there's a general boundaries rule that people will forget. It used to be in Rule 278 of the Land Registration Rules of 1925. It was enshrined in the statute, Section 60 of the Land Registration Act of 2002. And Section 60, subsection 2 in particular, says that the boundary does not determine the exact line, the plan, does not determine the exact line of the boundary. So the boundary was clearly, from inspection and likes, where the fence was on first registration, and they succeeded. A mixture of adverse possession and the general boundaries rule. The seller who sold to Narga in 2020 didn't actually own the land to sell, and the general boundaries rule is such that it'll identify the property, it's Brook Barn that she bought. It doesn't identify the boundaries. It's always worth remembering. I always remember a case, 2011 case called Drake and Fripp from near Wadebridge in Cornwall, where it was about between 4 and 5 meters between where the boundary was supposedly, if you looked at the land registry and the file plan, and where it was found to actually be. And they did that on the basis there was a sort of Cornish hedge, bank, and then a stop-proof fence about 4 or 5 meters further away. And they decided the fence must be the boundary and not the hedge, as the land registry had it looked like at the land registry, because they referred to the person having to maintain the stop-proof fencing, which sort of suggested it should be on your land. So you can't rely on the file plans even to the tune of 4 or 5 meters. What the Court of Appeal also said is it cost them over £300,000, the combined costs to get to the Court of Appeal. And she really, when she bought this property in 2020, she apparently said that she'd turned up and visited the house that she was wanting to buy 8 times, and it might have been a good idea for her to actually just chat to the neighbours about where they thought the boundary line was and save everybody a lot of time and effort and 4 years of effort. That's what happens when David disputes, Lizzie. Irrationality prevails.
Well, thank you very much, Richard.
My pleasure, as usual, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.